Good day, everyone. Our program will begin in just a moment. Hello, everyone. Thank you for joining. Our program will begin in just a moment. Good day and welcome to Advocacy Anywhere, powered by American Jewish Committee. Advocacy Anywhere is AJC's digital platform that enables you to engage with AJC's global expertise, content, and advocacy from wherever you are. In July, the Israeli Knesset passed legislation which, if it withstands judicial review, would limit the High Court of Israel's ability to apply a reasonableness standard when reviewing certain administrative decisions made by elected officials. This highly contentious legislation is part of a larger debate in Israel over reforms to the country's judiciary. Joining us today for an updated and in-depth look at Israel's ongoing judicial reform is renowned Israeli lawyer, former senior legal advisor, and frequent AJC Project Interchange speaker, David Benjamin. Moderating today's conversation is AJC Board of Governors Chair, Bobby Lapin. After we hear from Bobby and David, we will take your questions. You may email your question to questions@ajc.org. That's questions plural, or you can use the Q&A feature in Zoom. And Bobby, I turn the floor over to you.
Thanks very much, Daniel. And David, Benjamin, good morning from Texas. Good evening to you in Israel. And thank you very much for joining us today.
Thank you for having me.
As our summer comes to an end and as things gear up for the fall, it goes without saying that these are momentous and there are some very consequential days ahead for Israel. And like so many American Jews, we at AJC who care so deeply, candidly, for the people in the state of Israel, have been following the events of the past 8 to 9 months very closely. And as we now return from our own summer breaks and travels and begin to ramp up our own advocacy efforts on this end, we thought it would be helpful to have a refresher of sorts and remind ourselves of just where things stand with regard to what all has been happening in the halls of power, in the courts, and importantly on the streets of Israel with regard to the judicial reform legislation. And toward that end, David, we are very grateful to have you with us for this refresher. And let me see if I can kick things off perhaps by setting the table for our discussion by reminding our audience of some of the very high-level key milestone events which have brought us to this moment. It began, of course, last November when, as a result of the fifth election in less than 4 years, Bibi Netanyahu emerged with a coalition that was controlling a majority of 64 seats in the Knesset. And that coalition, arguably the most right-wing and ultra-nationalist in Israeli history, rallied around the prime minister and soon announced as a top agenda item a sweeping legislative package of so-called judicial reform that was led by Justice Minister Lapin. And because this judicial reform package was viewed by a broad swath of Israeli society as fundamentally changing the balance of power and the checks and balances of the democracy, which had undergirded Israel's first 75 years, this proposed legislative package resulted, to say the least, in staunch resistance and, beginning in January, really unprecedented demonstrations by many segments of Israeli civil society, including, of course, from the economy, academia, high tech, and notably volunteer military reservists. And then in March, we, of course, had the incident where Defense Minister Gallant expressed his opposition to this judicial reform package, and he was temporarily fired by Prime Minister Netanyahu. That event sparked a huge amount of civil unrest and demonstrations, resulting in the prime minister deciding to de-escalate the crisis by announcing a pause in the effort to pass the judicial reform package. And then, as we'll all remember, of course, in the ensuing months which followed, Israeli President Herzog proposed some broad outlines of a potential compromise. He attempted to facilitate discussions between the government coalition and the opposition, but those talks failed to produce a compromise. And then in late July, just a little over a month ago, the government coalition changed tactics. And rather than moving forward with a complete judicial reform package, the prime minister decided instead to proceed forward with one element of that legislative package. And it was an amendment to a basic law that was known as the Reasonableness Standard or Reasonableness Doctrine. And then prior to the Knesset adjourning for 3 months or so until after the High Holy Days, the coalition pushed through that law, through the Knesset, with the opposition entirely boycotting the parliamentary vote. And then days later, the Israeli Supreme Court announced that the High Court would hear appeals of the legal challenges to the legislation which had just passed, setting up what at least I'll call a potential constitutional crisis, where you have the highest judges in the land considering whether to strike down legislation which was expressly designed to limit their power. So, David, in a mouthful, that's my sort of amateur effort to bring us up to speed and to set the table for the questions that I'd like to pose to you in this discussion. And of course, I want to ask you why the coalition decided to make the reasonableness standard the first plank of judicial reform to be passed. But before I get there, and to take advantage of your extensive legal expertise, help us understand, if you would, please, what exactly is the reasonableness standard in the context of the Israeli system of government, and how important has it been traditionally in the system of checks and balances?
Yeah, thank you, Bobby. And again, I'd just like to say this is a great honor and a pleasure. So thanks to you, thanks to AJC, and thank you for all of you who are listening to this. It may be difficult to imagine for Americans, North Americans, but we don't have a constitution in Israel. And I would venture to say that is the root of the problem here. We don't have a constitution. There are so many things that there just isn't a set way of resolving them or doing them, okay? So how do we actually even operate without a constitution? Well, the answer is some of the time our legislature, the Knesset, legislates laws. There's a special kind of law which we call a basic law, which is not a regular law. Basically, it becomes a basic law because the Knesset calls it as such. And those are laws which are generally understood both by the Knesset and also by the court itself to have a constitutional status. So what we like to talk about in Israel is that we have an emerging constitution, which is made up of several basic laws. But those basic laws are very scant. Okay, they only really cover a very small amount of ground in terms of what a full-blown constitution should cover. So that's the situation as it stands. Now, so how have the gaps been filled in? Well, partially, as I say, by the basic laws of the Knesset, but also to some extent, and over the last decades to a larger extent, by the court itself, by the Supreme Court. As basically, when there's a vacuum, sometimes you have to fill it. And the court has been busy sort of working on the constitutional issue of what is the correct relationship between the Knesset, the administration, and the court, and what is the interaction between them. So the existing situation is a product of, first of all, the basic laws, but also of the interpretation of those laws and various precedents enacted by our Supreme Court. That's all there is at the moment, okay? The problem is, and it depends who you ask. If you ask the critics of the current situation, they will tell you the current situation is such that there is a dictatorship of the Supreme Court. At the end of the day, the Supreme Court has the final word on just about everything. At the end of the day, it can potentially, at least, or hypothetically, strike down any decision of the Knesset, of the legislator. This is not a healthy situation. Not only is it not healthy, the critics say that this has been, to some extent, used to promote a certain agenda, which they would call sort of a left-wing elitist agenda. Not everybody would agree with that characterization, but that's what the critics say. And of course, the other end of the scale says, no, the danger of what we're talking about now, which isn't the case in Israel, but is what the reformists want to achieve, is a dictatorship of the majority, which is also a threat to democracy. Remember, when we talk about democracy today, we don't just talk about majority rule, because we know that there have been very bad examples where majorities have done terrible things to their country. And so that generally today, when we talk about democracies, we talk about constitutional democracies, or let's just say democracies with checks and balances, so that a legislator can't just go wild, or a government can't just go wild. Okay, there are all kinds of, let's say they will encounter all kinds of friction on the way before they can actually enact something. So of course, it's obvious in the States, you have checks and balances are the name of the game. You have a full separation of powers. You have two houses of Congress. for anything to change in the United States, there are a lot of things that have to happen. In Israel, there are basically three bodies of government. All right, there's the Knesset, which is the legislator. There's the government, okay, and there's the Supreme Court. But when I say three, okay, that's not quite true in practice. The reason being is the way the Knesset works is we have a what we call winner takes all, first past the post system. In other words, whichever party wins the election, okay, they basically get to rule the roost, okay, and the people who lost the election are consigned to opposition. They have no effective power, because if you have a majority in the Knesset, then you can basically, you can pass any law you like, and no one's going to stand in your way. Obviously, that's because of a norm of what we call coalition discipline. In other words, once there's a coalition by that I mean, generally in Israel, no party by itself has been able to get a 51% majority in the Knesset. So they've always been forced to join with other smaller parties to make up that majority. But that's the ruling coalition. Basically, whatever the ruling coalition wants goes. So in the sense that there's a greater meaning to the legislator, the Knesset, over and above just what the ruling coalition says, there isn't really. Okay. I mean, obviously things are discussed. There's a discussion process. Hopefully the coalition will listen to objections and listen to arguments. But at the end of the day, when it comes to decision-making, it's the coalition rules. Now, when I say the coalition rules, that can be a very, very narrow coalition. The current coalition has 64 seats out of 120, but that could even be a coalition of 61 seats. They would also be able to actually pass anything they like, okay? What is the only check balance preventing them from doing that today? That's the Supreme Court. All right, that's enough background. And let me talk about the reasonableness clause. All right, so on what grounds can the Supreme Court actually supervise or intervene with decisions of the government? So there are various established grounds. The one is, of course, if the government acts without authority, doesn't have jurisdiction to do a certain act. That's a basic thing. If the basic rule of what we call administrative law, which governs this whole area of what the government can do and can't do, it says that a government official or a minister can only do what they are empowered to do by legislation. What they're not empowered to do by legislation, they just can't do. So that's the first test. Okay, if a government minister makes a decision, are they empowered to make that decision? The second test is, did they follow the correct procedure in making that decision? Many decisions have a certain procedure that needs to be followed. If you don't follow the procedure, the court can strike down that decision. And then there's a third criterion for judicial review, which is here more difficult, okay, which actually looks at the content of the decision. But in the sense that, is this content, okay, does it comply with certain criteria that have to be met? For example, is it in good faith? Are all the considerations that have been taken, are they relevant considerations? Again, is it done within the powers of the relative of the official? Proportionality, equality. Okay, these are grounds on which the Supreme Court can overrule and intervene in an existing government decision, and including legislation of the Knesset. Okay, that includes legislation of the Knesset, okay, which is subject to review under a specific law, which is a basic law. There's a basic law called the Basic Law of the Dignity of and Freedom of the Individual. Okay, and by interpretation, at least, the Supreme Court has understood that it has the power to strike down legislation of the Knesset if it doesn't accord with the principles of that basic law, which basically deals with fundamental human rights. Now, what is the problem with these basic laws? Okay, there is no agreed mechanism, okay, as to what constitutes a basic law. And how do you make a basic law? Basically, if the Knesset says this is a basic law, it goes. So actually that big basic law, that in many respects, maybe the most important one, which protects human rights in Israel, the dignity of the individual and freedom, was actually passed by only 23 members of the Knesset, believe it or not. Now, there was quite a lot of consensus behind it, but formally speaking, there were only 23 members of the Knesset who were there on the day and voted for that law. And that became then the basic law and the yardstick by which the Supreme Court can measure legislation, if necessary, strike it down if it doesn't meet the requirements of that basic law. So as I say, we're in a position where we don't even know how to go about making these constitutional changes. There's no set way, right? Now, the current coalition wants to go about making some constitutional changes. And one of the changes it wants to make is to, at the moment, it has a whole list of changes they want to make, but that at the end of the day, sort of increase the power of the government and lessen the power of the Supreme Court to supervise the government. Again, there's a debate about to what extent that's desirable or what isn't. Of course, there's an argument which says at the end of the day, in a democracy, the power should be to the people, the majority of the people. But again, there's always the danger of the tyranny of the majority, and that needs to be balanced out. So there's two balanced considerations, and there's the legitimate argument about where exactly should the balance lie. Let me just open parentheses and say this argument is taking place against a very, very fraught political context, which I'm sure actually influences things. Okay.
And may I forgive me 1 second? I want to draw an important distinction here, exactly where you are right here, so we can narrow in on the reasonableness standard issue, so that we can be clear. And please correct me if I'm wrong. What is currently off the table, at least for based on the Prime Minister's more recent statements, was the question of trying to eliminate the High Court's judicial override power, the Knesset's power to overturn a judicial judgment by a single majority vote in Knesset. That's the judicial override piece. That's off the table. What we're talking about now is the law that is passed with regard to the reasonableness standard. And that really, correct me if I'm wrong, David, that really focuses in on the court's ability to review ministerial decisions, not necessarily Knesset legislation that is passed, but administrative ministerial decisions, which have grown and become a very significant part of decision-making in the Israeli society. And the tradition has been, as I understand it, that the court has become a little more robust in recent decades in terms of intervening to overturn ministerial decisions. We in the States are familiar with situations where Congress, for example, will pass enabling legislation allowing a government cabinet to act, such as the FDA or any number of government cabinets, but then the cabinets themselves initiate and pass a bunch of regulations which in effect enact those laws. It's really those administrative regulations and the administrative decisions that the reasonableness standard focuses on. Is that correct?
Thank you. Yes, Bobby. And thank you for sort of focusing me in. Okay, I hope I gave enough of a background against what this is all happening.
No, very helpful.
This whole what is happening. So right. So what I didn't mention, and I'm going to mention it now, is one of the criteria that the Supreme Court has used to measure legislation, okay, to assess whether it's legal or not, basically, and whether it needs to be upheld or struck down or altered, is what has become to be known as the Reasonableness Standard. Okay, now there was a time when I mentioned there are various grounds for judicial review, like lack of good faith, extraneous considerations, lack of proportionality, lack of equality, this kind of thing. Okay. There was also a ground called gross unreasonable. So in other words, if something is unreasonable to a degree that is just completely irrational, that no rational person could possibly make such a decision. Okay, that's the origin of the idea. And it's something that exists in several countries. It's not an Israeli invention. Okay, the Supreme Court has developed that quite significantly over the years. And one of the criticisms has been that the court has gone a bit far. Okay, that this test of reasonableness is not quite as objective. Okay, in fact, if you look at different cases, they will point to a certain inconsistency reasonable that they talk about in law. We talk about the man on the clap, or the woman, we should say, the person on the Clapham omnibus. That's an English law term. Sort of about the Joe Schmo, right? The person in the street. Okay, what would a reasonable person say? Okay, obviously that can be widely interpreted. So the critics of the current situation, where the court uses that reasonableness standard sometimes, as you correctly say, to examine and sometimes strike down decisions of administrative bodies, not the Knesset, administrative bodies, which can include the ministers and the government itself. As I said, there's controversy about how that's being used. Okay, and the current law now, which has been passed recently, actually says the court is no longer allowed to use that criterion, okay, to supervise the government.
And give us a sense, David, how often has the court in recent years stepped in? I think I've read statistics that suggest that maybe about 10% or even fewer of administrative or ministerial decisions have been reviewed by the high court on the question of whether they're reasonable and whether they in fact properly enact the legislation that enable them. Is that about right in terms of the frequency with which the court has intervened and utilized the reasonableness standard?
Well, let me tell you from my experience. I was a legal advisor in the military, in IDF for many years, and as such often dealt with petitions that were filed against the IDF in the Supreme Court. Now, I'm not exaggerating. There were like literally thousands of petitions every year filed against just the IDF. Okay, but I think that was the main caseload of the Supreme Court. Okay, just think how different that is to the US Supreme Court, which kind of gets to pick and choose exactly what cases. But the Israeli Supreme Court then was dealing with literally thousands a year. Okay, a very small percentage of those petitions were actually granted. Okay, very small. Now, in some of the cases, I can tell you that's because the legal advisors of the government bodies, like of the IDF being petitioned against, would say, listen, we don't have a good chance in court, let's not take it all the way. All right, so that is one of the reasons. Okay, but also so as a general rule, the High Court has viewed itself as being reluctant always. In other words, let's just say the basic norm, right, in absence of anything else, is that the court doesn't interfere. There has to be a special reason to interfere, otherwise you don't interfere. And yeah, that's true. If you look statistically on the amount of petitions that have actually been granted, as opposed to the number of petitions filed, okay, there's only really a small percentage that have been granted, and even that of a very small percentage being granted under the reasonableness test. Okay, so there are examples, but again, very few relatively, if you look at the big picture of the Supreme Court.
And yet, even though there may be only a relatively small number of cases in which the court has deployed the reasonableness standard, if you will, to overturn the administrative decisions, would it be, do you generally agree with the view of the opposition in this case that it is nonetheless an absolutely critical check and balance on administrative power, because in the absence of the court having the ability to review administrative decisions on the basis of a reasonableness standard, you run the risk of having ministers of government, people wielding administrative power suddenly catering more to special interests rather than focusing specifically on the purpose for which the enabling legislation was originally enacted. Is that a fair concern and criticism in your mind as to for the sanctity of maintaining the court's right to be able to review administrative decisions on the reasonableness standard basis?
I mean, yeah, I would accept. I do accept that what you've said. I think the problem is that the reasonableness test is not sufficiently circumscribed up until today. Okay, and one can justifiably point to inconsistencies in the way it's being applied. And that will be the criticism of the current situation where the court does apply. Again, is that a major concern, really, if you look at the big picture? Okay. Others will say, if you look at the big picture, even if the High Court here and there has maybe gone a bit far, okay, is that really, is that Israel's number one problem today, right? But again, I think it goes back to the fact that we don't have a constitution, and there's actually no piece of legislation, basic legislation, which says what are the grounds for judicial review exactly, and how are they to be defined? It's only the court who has defined it for itself. And in many ways, as I say, on this particular doctrine of reasonableness, okay, there's a lot which is quite murky. So there is an issue with reasonableness. There is a problem of like, how objective can the standard be? Okay, but you've got to be careful about throwing the baby out with the bathwater, because if you scrap it all together, okay, you're scrapping what has been up until now a very important tool of judicial review. And there are all sorts of instances which the other existing grounds for review just don't 100% cover. Okay, this isn't, for example, about individual human rights. Okay, this isn't about violation of rights. Okay, it can be the classic situation. Did you want to ask something? Yeah.
No.
The classic situation of reasonableness, for example, is on political appointments. Okay, appointments of ministers, appointment of government officials, etc. Okay, there's no issue of individual citizens' rights involved. It's a question of good governance, right? And the court has used that standard from time to time to say, look, to appoint this particular individual to such a sensitive post, okay, is just completely unreasonable. Either the person has no qualifications, the person's a convicted criminal. You can't have a person, for example, with a past of stealing money from the government coffers. You can't make them the Minister of Finance, for example. Okay, that's one of the
well-known example,
right? Just one arbitrary example.
So
but the thing is, but there have been other examples where the standard has been, out of fairness, I must mention there are other examples where it's been applied, and those who are proposing the law, they point this out. For example, there was a decision by two ministers of education to not accept the recommendation of the board, which recommends who should get the Israel Prize. Okay, there's a prize which is given out every year for people who have high achievement in various fields, and this advisory board decided to recommend that a certain professor at the Weizmann Institute should be granted the prize, but two ministers of education said no, okay, because this person is an active supporter of boycotts against Israel. Okay, at least that was what was claimed about this person, and they said, well, he doesn't, he may be very accomplished, but he doesn't get the prize. And the court actually, it sort of went a few steps, but at the end of the day, the High Court forced the minister to give the prize to this individual. Okay, so some say, look, this is the court overreaching. You don't know. Remember, reasonableness is defined in the following way. It's not whether you like the decision or not. It's not whether you think it's the correct decision or not. It's the question is it reasonable? In other words, does it fall within the kind of range of reasonable possibilities? Okay, if it's outside the scope, then it's not reasonable. But even if I disagree with it very strongly, okay, is it still fair enough that the minister would make that decision? Okay, and they like to give say the current coalition like to give that as an example of like, what is the court doing with that kind of thing? There's another example which is actually raised by the opposition, which actually I think is not a good example. All right, so they say, for example, the court compelled the government to fortify all the classrooms in Sderot. Sderot is a town right next to Gaza, okay, which is under regular heavy rocket fire. Okay, so some people who are opposing the current legislation say, you know what? Look at all the good things that the reasonableness standard has given us. Okay, if the court hadn't ruled that, the classrooms would not be fortified. Okay, but now there's a very strong argument to say, with all due respect, okay, decisions like that on priorities of security. Do we want to spend money on fortifying classrooms? Do we want to buy another, F-35 jet, or do we want to buy more Iron Domes? Those are decisions you need to leave to the government. That's not the court's place to make those kind of priority decisions, right, on matters which are basically economics or security. So there are justified criticism, but again, there are plenty situations where reasonableness has saved the day. And that's what the many petitions which have been filed against the current law are all saying. In almost every field of activity, okay, there are potential abuses that could take place, potentially bad things, and the only potential solution that the court has to deal with those is the standard of reasonableness.
Okay, so and that's an excellent and much appreciated explanation of the standard. Let's zoom out now, because there are two topics I want to ask you about before we open up to the audience Q&A. As I want to really put this in the larger context, right? One would not, even in the United States, think that the nuanced discussion of the standard of review of administrative decisions would be something which in and of itself would result in hundreds of thousands of Israelis taking to the streets to protest, the Israeli stock market tumbling, military reservists threatening not to show up for reserve duty, et cetera, et cetera, et cetera. So there's obviously a larger reason why this particular event has had this particular effect. And help us understand, is it because, and the government has said, look, this is just one step we're taking here. This is all we're doing at this point. And yet the protests not only have maintained, but they have in many ways grown and become enlarged. And is it because there is a concern that this particular first step of the reasonableness standard legislation is seen more as a stalking horse for a larger and more sweeping judicial or even non-judicial agenda that's going to be advanced by the coalition? Is that the main reason why the protests have continued and have magnified in the face of this seemingly singular act on the part of the government? Or what's your take on that?
Well, first of all, certain elements of the coalition are still very vocally expressing the fact that they intend to go the whole route. Okay, it's true that the Prime Minister has said no, we're going to make do with this, and then another reform down the road of the constitution of the Judicial Selection Committee. But we know that in his coalition, okay, there are forces pressing for much more sweeping reforms. And people will say, well, you know, to a large, again, the critics of the current government will say that the Prime Minister is in a coalition which forces his hand on many occasions. Okay, so even if he would personally like to just see this thing go away, okay, it's not going to happen so easily, okay, because he has to handle this coalition. Because he has a choice between somehow appeasing or handling this coalition or managing this coalition or losing power altogether. And in order to appease that coalition, he has to throw them bones, if you like. Okay, so this is the suspicion is, okay, he's doing this now, he's throwing in this bone to keep them quiet for the moment, but it won't satisfy them, right? When you start feeding the alligator just wants more, right? From Peter Pan's story. That is basically the idea. The government has not taken entirely, let's say the coalition has not taken the rest of the program off the table. Of course, that doesn't you know, do away with the need to discuss what's actually on the table now, because the critique is this is not a serious law. Okay, this is just there shouldn't be a law that looks like this in the first place, right? What should be is there should be a constitution, and one of the clauses of that constitution should say what are the powers of the court to review, okay, administrative action, and it should say when can it use reasonableness, in what circumstances, etc., etc. There shouldn't just be an isolated piece of legislation that says whatever you do, you can't say something is unreasonable. That's just from a legal, you know, from a lawyer's point of view, that is not an aesthetic piece of legislation. It shouldn't work like that, right? The powers of the court should be defined in a positive way, not in a negative way. There's something wrong with the whole approach. And if people are concerned that lurking behind this, as you say, what could, like if this was happening in a vacuum, if this discussion was happening in a vacuum, in an air-conditioned room on some Ivy League campus, okay, yeah, sure, you could be a back and forth about what is the correct balance between the branches of government. Okay, but the background here is much bigger. Okay, people, what the protesters see is not only these kind of academic legal questions. What they see behind it is a coalition, or at least some elements of the coalition, who want to take advantage, okay, of these proposed reforms to push through an agenda which they find quite horrifying. Okay, now let me say something as someone who's been around for a long time. I was a military advisor for a long time. We had to deal with the fact that, and a lot of people don't understand Israel for this reason. Okay, it's important to point out. We had to deal with the fact that while we were busy, you know, with military operations, we had ministers in the government, who were saying, yeah, for every rocket that gets fired out of Gaza, we need to wipe out the entire village from where the rocket was fired, right? We had ministers in the government saying that. Needless to say, when we have to deal with international tribunals afterwards, those ministers get quoted because they, as representing the government. Okay, what not everyone understands is you can't judge the Israeli government on what people are necessary in the government, even if they're in the government, on what they're saying. Okay, it doesn't work like that. In the States, right, the president appoints all the ministers. Okay, it doesn't work like that in Israel. You have people who are ministers who are fighting the government. Okay, and they say things on their own accord which don't necessarily align with the views of the government, and it gets us into all sorts of trouble. Okay, most of the trouble that we're in today is about things which have been said, a lot less about things which are actually being done. Okay, so I would recommend, okay, without in any way want to be an apologist for the government, but I would recommend judge Israel on the bottom lines, like what actually happens in practice. Okay, because there's a very, very convoluted, very complicated decision-making process that goes on here. Okay, which can be very misleading in terms of who that a senior minister might say something which is completely not in line with actual government policy as it is practiced. I would be careful with that. Yeah.
Okay, fair point. And I want to touch on one other item before we go to the Q&A, and that is you just referenced the fact that Israel has no constitution, and we're in this situation now where you've had the Israeli High Court decide to review the reasonableness standard legislation that has been passed. Now, we in the United States are very familiar with the practice, the doctrine, if you will, of judicial review in that situation. Many people, non-lawyers, don't remember that there's nothing in our Constitution which says that the Supreme Court has the right to review legislation. That was something that was enacted in Marbury versus Madison and became an established practice that's recognized here in the United States. But in Israel, you not only have no constitution, as I understand it, you have no real precedent necessarily for the very situation we're in now, where you have the High Court has agreed to review this piece of legislation that is expressly an amendment to a basic law and yet limits the court's power of review, admittedly in a somewhat narrow context. And the question is really two parts, and we'll try to keep it concise if you can, so we can leave plenty of time for questions. But number one is, you're a lawyer, give us your handicap for us. What are the chances that you think the High Court would overturn the legislation? And number two, if that happens, what comes next? Is there a constitutional crisis? What if you have Knesset saying you have no power to overturn us and the court has overturned it? Where is Israel left in that situation?
Okay, well, first of all, just on the legal side, you're correct. The Supreme Court has never overruled a basic law. It hasn't happened. Okay, what has happened is what we lawyers call obiter. Okay, obiter are things that the courts say in the course of their decisions, okay, but they don't have an effect, an impact on the final decision. Right?
We call that dicta in the United States.
Obiter, dicta, obiter, okay, so something between obiter, dicta, different ways of describing it. Anyway, so these are statements which are said. So what has happened is that challenges have been mounted to basic laws in the past, and the court has agreed to hear those challenges. The court has not yet overruled the basic law, but it has agreed to hear what the arguments against the basic law. Okay, you may be familiar. It's quite there's a basic law which was enacted in 2020, which is called the Jewish nation-state law. Okay, which was quite controversial, and that was petitioned against by various groups. And the court at the end of the day said, well, they said they did recognize that they had the right to actually overrule the law, but they didn't do so. Okay, so in that sense, there's precedent, but not in an actionable sense. It's not a real precedent. It was said by the court that they would potentially have the right to do so. And there was another completely technical case where also they almost came close to overruling a basic law, something to do with the Speaker of the Knesset and elongating his term of office, something quite technical. But there the court almost did step into the breach. So there's no precedent, actually. It's never been done before. Again, the problem is there's no mechanism, okay? There's no recognized mechanism for enacting a basic law. Now, let me just say, if you ask me what the solution is, and I hope this is the solution, all that needs to be agreed upon by a significant majority of the Knesset is how many Knesset members do you need to pass a basic law? Okay, a law that is it rises above other laws, okay? Because if you have a sufficient majority, then you might say, okay, then there's a case to say the Supreme Court shouldn't be messing around with these laws because they have a constitutional impact. It's like the United States Supreme Court wouldn't cancel the Constitution, as far as I know, right? The Constitution is rocks. You can't mess with the Constitution. You can only measure laws against the Constitution. So I think that would be ideally the answer. We can all agree upon that a basic law needs to be passed by a certain majority of the Knesset, over and above just, of course, what necessarily could be a narrow coalition of just 61. As I say, today, 61, that's all it takes, and you make a basic law. You can say, well, any basic law you want. I mean, in theory, you could say, tomorrow, the Supreme Court will cease to exist, basic law. Okay, you could theoretically do that. I'm not saying it will happen, but let's, if we can, let's focus on exactly where we are now, which is the court has decided to review this particular piece of legislation. Do you think, handicap for us, do you think the court will overturn it? And if it does, what results from that? Do you believe the Knesset would recognize it? I realize this is crystal ball stuff, but you're on the hot seat, so we'd love to hear your perspective on it. Okay, so there are a couple of, let's just say, half measures that the court might take, okay, sometimes, and it's used these tactics in the past. The one is to say, look, this is very problematic. We don't want to rule on it. We're going to send it back for re-evaluation, reassessment, rediscussion. Okay, so that's something that the court can do. Say, well, we're going to postpone our decision on this for a while. We really, really think, because it's so problematic, that the Knesset should revisit this and consider it again. Okay, that is a possibility. It's been done before in other contexts. Another possibility is for the court to just say, okay, we go with this, no problem. And then what they'll do is they'll find a workaround. In other words, as I say, there are other existing grounds for judicial review. In any case, the grounds for judicial review have been established by case law. They're not to be found anywhere else. Okay, so the court can sort of come up with, can expand maybe existing grounds, other existing grounds, and sort of get around them. I mean, I'll tell you what I think is an intriguing possibility, at least what I thought. As I said, we used to talk about gross unreasonableness, like irrationality, okay? And now the talk has become reasonableness. And actually, the wording of the law says the court may not strike down a law because of, unreasonableness. What it doesn't say is gross unreasonableness. Okay, now maybe there are clear reasons that no government is going to want to write a law which is, we don't want anyone striking down our laws because they're grossly unreasonable. Okay, but I actually think there's a window there for the court. The court can say, fine, you know what, reasonableness is it's not good enough. It's not. It has to be extreme.
So they can increase the standard, but or increase the bar, raise the bar, but maintain the right of review.
Perhaps. Yeah. So those are options, and of course they could just say no. We don't accept this. This is it. And then there will be a constitutional crisis of sort. Okay. Then the Knesset, the government, has to decide, what do we do now? We don't at the moment. This is something they want, right? Which they wanted, right? Is to have an override clause, to have an override law, which says that the Knesset with 61 votes can override any decision of the Supreme Court, right? They don't have that law yet, okay? Until they have it, it's not, basically the situation is now that the government has to abide by the decisions of the Supreme Court. If they refuse to do so, let's say there's no precedent for that. So you'll really be in uncharted territory, so to speak.
All right.
My guess is the court will try and find a sort of sophisticated, will dance around it and try and find a sophisticated, elegant way around it. That's my guess, but I don't know. I really don't know.
And we'll find out soon enough. Okay, look, there are so many other questions I've got, but I don't want to dominate this any further. I know we've got some, maybe in 15 minutes or so, for questions from the audience, and my apologies to the audience if I ask too many questions, but I really wanted to get so much of this on the table, David, and I'm grateful for your answers. Daniel, let me flip it back to you. I know you're curating some of the questions that are coming in, and it's all yours for the moment.
Thank you, Bobby, and thank you, David. David, I'm going to give you two questions here that are somewhat related. The first from BJ Hoffman is asking, can we agree that if we allow the current government coalition majority to unilaterally alter the current system of checks and balances, that it opens the door for the next governing majority to do the same in reverse? And then Judy Greenstein is asking, if this were suggested by another government, do you think it would have created this furor?
Okay, so yeah, they're sort of related questions. So the answer is to the first one. I mean, that is, I mean, that's why one of the reasons I think this is not a right-wing, left-wing thing. At least it shouldn't be, in my opinion, because potentially, if the government gets these things through and then falls tomorrow, okay, a different government with a very different agenda, okay, can use these same amendment to its own benefit. What the fear is that the people who are objecting, they say what this government can in a very short amount of time, okay, once it manages to sort of strip the Supreme Court of sufficient powers, okay, or to alter the way, the structure, the composition of the Supreme Court, okay, it will be able to fundamentally make changes which will be very difficult, if not impossible, to change in the future. Okay, that's the fear that people have, that in a very short amount of time you can, and that was the fear because the government initially was like basically trying to bulldoze the whole reform, the whole package through in a very, very short amount of time, including the override clause, including other things. It's kind of a whole package. So that's the fear. If it's justified, some elements of the government are quite openly, let's just say, not very democratic. Many of them are saying, listen, this is just democracy. You don't have to worry about democracy. Trust us, it'll be fine. We don't intend to tear the whole edifice down. Okay, we just want to recalibrate, right? So the opposition doesn't want to buy that. Okay, as I say, there are two elephants in the room, not elephants. Let's just say that they're very much relevant. Okay, which are kind of sort of, if you like, and this deals with the second point, which are kind of, if you like, polluting the discussion, right? The one is the current nature of the coalition. Okay, where some of its members are like openly saying, cheerleading for as much judicial reform as possible because they see the Supreme Court as being the main obstacle to pushing through a very problematic agenda. Okay, which is not a very strong connection to human rights or the kinds of things that most people would support. And of course, the other issue is the fact that the Prime Minister is actually in the middle of a trial at the moment. Okay, and just about and which is an absurd situation that an acting Prime Minister is on trial. Okay, but what it does is it kind of puts a cloud over every decision the Prime Minister makes. People are always going to argue that's a conflict of interest. He's doing this to somehow advance his own interests within the trial. So the problem is the context is has so much influence over the discussion. Perhaps this discussion could have taken place in a different government. I mean, I don't think it should be happening the way it is. I think what the first thing they just need to do, if we agree on a number of members of the Knesset who have to agree on a basic law, okay, and then, which means there has to be, by definition, there has to be wide agreement on what the reforms are, then I think we're okay. That's fine. But if it's just left up to a narrow coalition, it could be a right-wing or a left-wing coalition to sort of change the rules of the game, so to speak. That's what's problematic. It needs to be, surely it goes without saying that a constitutional reform, which really does affect the rules of the game, needs to be something that is achieved with wide agreement. It can't be just narrow, pushed through by using a very slim majority, which happens to be at the time.
Great, thank you. Our next question from Lauren Blatt, and actually several others have similar questions, but Lauren's asking specifically about women's rights, but I would add minority rights in general. Are they at risk with the Supreme Court being able to protect them from unreasonable legislation?
Some people say they are to some extent. Others will say, equality, like the principle of equality continues, hasn't been scrapped as yet. So obviously, the issue of women, the women's status, etc., could be dealt with. That proportionality, those sort of criteria, which are still very much there and available to the court, can still be used. But potentially, yes, because see, the problem is this, for example. One of the reasons for judicial review is what we call irrelevant or extraneous considerations. In other words, considerations which are taken into account, which aren't the real reason, aren't the correct reason, ulterior motives, right? There's a very big problem to prove the ulterior motives. Okay, that's a problem. And the reasonableness standard has become a way to sort of solve that problem. Instead of looking at getting evidence that actually there's lack of good faith or an ulterior motive, if something is unreasonable on the face of it, that's good enough. Okay, you don't have to start bringing evidence that there's something fishy going on behind the scenes. That is actually probably the main advantage of the reasonableness doctrine. Doesn't require that. Okay, the court of appeal, the Supreme Court is not a court of evidence. It's a court where people bring legal arguments. It'll be very, very difficult to sort of get evidence of misuse or abuse. And that's why reasonableness is so important. So I do think, I don't think women's rights have just gone out the window, but I think certainly it will be harder for this law makes it harder for the court to review. Okay, it'll make it harder. Not impossible, but definitely more challenging.
Great, thank you. Our next question from Andy Marks. As I understand it, there are 4 Israeli Supreme Court justices who will reach the mandatory retirement age of 70 in the next 2 years. Does that mean that a reconstituted judicial selection committee dominated by the current coalition would within 2 years be able to select more than 25% of the Supreme Court and appoint all very ideological jurists? And by appointing younger jurists, ensure they will remain on the court for 20 or even 30 more years until their mandatory retirement age?
Well, the short answer is yes. I mean, that's the fear, is that if the court is dominated by the coalition, if the Judicial Selection Committee is dominated by the coalition, or there's a built-in mechanism which is sure that at the end of the day the coalition has final say, that could be the case, and that's what the big objection is. Because in America, you might not find that particularly troubling, because the whole system of appointments is politicized, because it's not just, you know, there is supervision over it, right? It's a serious process. It's not just you know, a coalition appointing just who it wants, but no, you know, there is that. Israel has been always proud that its judicial selection is not politicized. That it tries, at least makes an effort to go according to objective standards. Because you can criticize it, you can say there's a preponderance of, like, say, Ashkenazi judges. Okay, if you look over the history of the court, most judges come from an Ashkenazi background. If you look at the number of conservative judges, in the sense of those who are more activist, right? We talk about an activist judge who is more inclined to interfere with government action, and people who are less inclined, okay, more conservative, say, you know, we're less inclined to interfere. Maybe it's true to say that there are more, you know, there are more activists than conservatives, but that's changing. That's actually, in the last round of appointments of the last few years, that has changed. We have now people who are definitely on the more conservative side who are on the court. So Israelis are very reluctant to sort of give up a system which at least tries to be objective and non-partisan as possible. Of course, no system is entirely that way, but just to have a system where the coalition at the end of the day decides who gets on the court is very troubling to people here. You know, even if that's what exists in other jurisdictions.
Question from Howard Goldman is asking what the likelihood of Israel adopting a constitution in the future is.
Okay, agreeing on a full constitution, that's probably a little while away. Okay, for example, on the elements of, like, religion and state. Okay, that's very much a sticking point. I honestly don't think it's that ambitious to think that we could reach agreement, at least on issues like judicial review and the powers of the Supreme Court. That to me seems like something that one could possibly reach agreement on. Again, this shouldn't be a question of left wing, right wing. Okay, again, the suspicion is that as I said, this process is tainted because the judicial reforms, as they're being presented now, they look like just a way for the current coalition to get its way on all kinds of things. Okay, which many people are unhappy about. Say, if the discussion took place in a special constitutional committee, which was constituted for that, and it was given time, you know, and they would bring experts from all over the world and do comparisons, etc. And at the end of the day, the Knesset would decide on a basic law regulating this, you know, with a substantial majority of Knesset members. That would be the way to go. I don't think that's such a tall order. I would think that's something that most people in this country can agree upon. That the current politics are preventing that from happening. It's like they're preventing from a unity government from happening, right? There could be potentially a unity government in Israel which throws out the extremist elements, okay, and kind of, you know, brings things back, you know, quite quickly back to normal. But it's not happening for all kinds of internal political reasons.
Thank you. And with our limited time remaining, I want to ask one final question from Ray Termini, but a few others I think have probably similar questions, which is that President Herzog has been working hard for all sides to agree to a compromise proposal. How likely is that? And if likely, what will that look like? Well,
you know, I'm not sure the president framework is really the right framework. It's kind of an ad hoc framework that the president, you know, really kind of nobly stepped in to kind of save the day. But that's not really the way it should work. As I say, the way it should work is that some kind of constitutional process should be set in motion, which really aims for wide agreement on the big issues. At the moment, I mean, what's being said, the government has, at least declaratively, okay, and at least the prime minister, okay, to the extent that as I say, the prime minister can commit long term, you know, given the pressures of his coalition. What he has said is that we're going to make do with a reasonableness clause, okay, and then down the line we're going to be looking at the composition of the Judicial Appointments Committee, and that'll be it. In other words, the rest of the stuff that we've been talking about won't be on the cards. Okay, and he might have a sense that, okay, so look, the reasonableness clause was done now because there was a sense, I think, in the coalition that this is the least controversial, okay, because kind of everyone gets that there's a problem of objectivity when you talk about reasonable. Everyone gets that, okay. The opposition, as I say, is because we don't have a comprehensive decision about what the court can do and when it can review and how it should review things which are problematic. And second of all, because of like the ulterior motives that everybody suspects, and the fact that this is just the first, we call this the salami method, right? It's piecemeal. First you get this down, and then you take the next part until it goes all the way, and the court is kind of eviscerated. I mean, that's the suspicion. That's what the opponents of the reform are saying. This is just the beginning. You take this away, the court is already a bit weaker. So I don't know if the presidential route is the way to go, but it might be the only one, because if the government is incapable of saying, wait, let's just be, let's be serious about this. Let's stop this unilateral push. Let's try and get consensus. The presidential route is not the way to go. There should be a proper, consensus-based constitutional process.
So, David, the hour is at an end, much to our regret, because there's many more dimensions of this I know we would love to touch upon. I want to first of all thank you for helping to illuminate some of this for us. The context, this is all very nuanced stuff. There's a level at which it's critically important for those of us who are about to sit around our Rosh Hashanah tables and want to be able to speak literally about this and do our advocacy work. There's a certain level of understanding the specifics that's very critical for us. We also, of course, never want to lose sight of the larger picture and the impact that this has, both for what is to be held in store going forward for the Israeli society, and of course for diaspora Jewry here, which is inextricably linked and ever will remain so. And so it's a matter of great importance and significance to us on our end. And we will continue at AJC, whether it's through our statements, whether it is through our informational pieces, whether it's through programs like this, that we will endeavor to always try to throw light on the specific substantive aspects of what we're talking about, and then step back a little bit and talk about what's the impact of all of this. And toward that end, you very much helped us today understand this piece of what is happening. It seems abundantly clear that it's going to be an active couple of months coming up ahead for the state of Israel as all of this unfolds. We will be watching, we will be listening, we will be caring immensely, and we will be speaking about this. So I want to thank you on behalf of all of us for joining us today. And any final thought or comment on your part before we turn it back over?
I think it's great that diaspora Jewry are engaged, and we said don't give up on Israel. Okay, I know some people are put off by all kinds of things going on here. Don't give up on us. And as I say, look at the bottom line at the end of the day. Don't always listen to all the voices that are being heard. That can be very confusing for all of us. Okay, but look at the bottom lines, and remember what, of course, Israel is much greater than just the current government in Israel. So even if you don't like the government, remember Israel is much more than just that. So stay involved, stay engaged, and thank you.
This is an audience for which I can assure you giving up on Israel is not an option, not a thought, not a possibility. And in fact, we lean in and continue to do so. So thank you.
You need to say that to others who I know there are, not necessarily in this audience, but there are others who are having these kind of thoughts. So I think it's important to say that to them.
Okay. Well, thank you again for your time. We wish you and your family a healthy, happy New Year. I wish the same, of course, Shana Tova, to all of our listeners and to their loved ones and families. And Daniel, let me turn it over to you to wrap it up, please.
Thank you, Bobby. And thank you, David, so much for joining us, for being with us. And a special thanks to our global audience for joining us today. To stay up to date on this issue and more, please visit ajc.org and follow us at AJC Global on Twitter, Facebook, and Instagram. Everyone, as Bobby said, Shana Tova. Have a great rest of your day and your week, and we'll talk to you soon. Goodbye.